Nous sommes en audience.
Mr. President, we are in open session.
Thank you. Prosecutor, who's your next witness?
Your Honor, the next witness is witness number P487. We will require, my learned colleague, Mr. Omafade, will be leading this witness. I wonder whether we might reconstitute ourselves. I'm not sure whether the court would like to take a brief adjournment or whether we can just move ourselves around.
If you can quickly move yourselves around, we can do something quickly.
We are allowed to do the same, Mr. President.
So, Mofade and Defense Counsel, are we ready to proceed now?
Mr. President, I do apologize, Your Honors. I'm trying to tune into the right channel. I was just trying to log on to the transcript for the records, but perhaps before we proceed, I could introduce the team as currently constituted.
Let's not do that again. We did that in the morning. The question for you actually would be, you have an application pending, don't you, for protective measures?
That's correct, Your Honor. There was an application filed on the 16th of this month. It's pending a decision from Your Honors for protective measures for this witness as well as 3 other witnesses. I wonder if Your Honors want to hear further submissions. We had nothing that's transpired since the 16th of October, so the request, obviously subject to what the defense and the victims and witnesses unit might have to contribute. The request will be for protective measures in the terms of the application.
Was it on the 16th or the 17th that you made the request for the accuracy of the record?
I'm sure Your Honor is probably correct and I'm mistaken. I believe it was the 16th. It might have been notified on the 17th. That might be the confusion.
Fair enough. And the chamber had indicated that the submissions on the application will be taken orally and an oral ruling will be made. Wasn't that the case?
Would Your Honors forgive me for a minute, please?
Fair enough. Your point, Mr. Mofade, is that your written matter suffices for any submissions you have. You have nothing more to say beyond what you've submitted in writing.
Your Honors, that's the position. Nothing's transpired since we made the filing and now to revise matters.
Then the defense have not responded to this application. Mr. Hooper?
Good afternoon, Your Honours. Indeed, that's right. So we can make some brief oral submissions now, which really come to this, because you'll see from the filing 1044 of the 17th of October that in respect of witness 487, the prosecution state that when the issue of in-court protective measures was raised with the witness on, and there's a redacted date, he said that he could testify publicly. And so it was seeing that the defence hopes were raised that indeed this would be a witness who could give his evidence in public without resorting to the protective measures that we recognise the court has found necessary, but which at the same time we can observe, of course, disrupts the public's knowledge of the evidence that's given. And I don't need to repeat to Your Honours the very strongly held view of this defence that public evidence is preferred as it's the most likely in our submission to expose the truth. And those are our submissions.
Ms. Bosman.
Thank you, Mr. President. We fully support these submissions made by the Ruto defense. We also would like to make a few observations, because the application is again based on very general observations about Kenya and the situation there with the proposal to withdraw from the ICC statute. This has been debated upon, and I will also not repeat what we've said. I just note that there's nothing specific to this witness to justify what I would say is a subjective fear on behalf of the prosecution. It's not even a subjective fear of this witness, because as my learned colleague just pointed out, he himself has indicated he was willing to testify publicly. But nonetheless, the prosecution is asking protective measures on the basis that it's not very clear. In fact, there's nothing specific, as I said. So they make these two general observations, and one is about Kenya. I would like to point out that we have this filing of the government on 15th of October 2013. I think you're well aware of that. And in this filing, the government actually explains how it works. Until now, there's no bill has been presented, so there's no change between now and the 18th of September when we discussed this matter earlier. Also, they point out in paragraph 12 of their submission that in addition to a bill, there must also be a cabinet memorandum prepared and submitted. None of that at this stage has been done. So the position of the Kenyan government is still a future matter, Your Honor, and it should not have any impact on this particular case. We also note that they go on about, generally speaking, the problem we had with protective measures. And it's true that the first witness had some issues, but there's not been a pattern so far. We know there was some concern about the second witness, but we are not privy to that information, so I cannot comment on it. But we've had 3 witnesses now without a difficulty. So we submit that you should stick by your own decision, going with an individual, case-by-case determination, and at this moment there is no reason to grant the protective measures sought. Thank you.
Prosecutor, are you in a position to discuss this fully? We're in open session. The defense have said that it appears to them that the witness has indicated no subjective fear, and in fact had indicated that testimony of the witness could be given in public. Do you respond to that?
Well, Your Honour, firstly, just to correct the record, the indication seems to be from my friend for Mr. Sang that as regards the first 3 witnesses, there's been no issue. That's far from the truth. I go no further than that.
No, I think she said as regards the last 3.
Well, even so, Your Honours. Secondly, and to the extent that I can explore this in the public session, I will, the fact that a witness subjectively states that they do not have concerns about testifying publicly. And in fact, this statement is more nuanced than it's been put forward by the defense, and Your Honours have the benefit of the filing itself. But even if a witness does say so, it is not the only considerations that Your Honours would have in mind. Your Honours would also consider whether the witness that states this is completely aware of all the facts that could mitigate against the removal or the decline of protective measures. And I say this for a number of reasons. The first being that the witness might not fully appreciate the risk to them from testifying in the absence of certain protective measures.
And that would be where the Victims and Witnesses Unit assessment comes in.
Which is why I said subject to submissions by the Victims and Witnesses Unit and, of course, the defence. It's all in the round that Your Honours make a decision as to whether or not protective measures are granted. But I go further. The witness might not also appreciate the risk to family members, friends, other associates that could amount as a result of the witness's identity being exposed. So there are a number of issues that Your Honours take into account in addition to the subjective wishes of the witness. But I go further to say that on this occasion, even the witness might not have fully appreciated the concerns when that statement was made.
Do you have more to say, either in public or in private?
Your Honours have the benefit of the filing. I have nothing to add.
Mr. President?
Mr. Narrett said saying, I forgot to get back to you. The computer has a way of blocking it. That's no excuse, of course. You may proceed. This is a witness of interest to you, isn't it?
To answer your question directly, Your Honor, no. But if you give us the opportunity, we would also like to make our contribution as to the protective measures to be implemented in this courtroom. Yeah.
Please proceed.
About the protective measures to be provided to each witness, I have personally consulted with Mr. Ndretu, the common legal representative, and made our position common. We believe that in this case, the prosecution's request should be granted in light of the fear that this witness expressed for his safety and the safety of his family. And we believe that those limited protective measures are justified and necessary, at the same time proportional. This concludes our submission, Your Honor. Thank you.
Thank you very much.
Your Honours, before you come to a decision on this, can I just make one point, and that is that we understand that now the protocol is such that there's a joint threat assessment, and so we have a position where the prosecution, no access to the defence, but the prosecution have been discussing with VWU the threat assessment. In those circumstances, and against a background where the witness himself has said that he'd be happy to give his evidence publicly, we hope and trust that the Chamber will necessarily scrutinise whatever the VWU say, because we don't have access to it and we are blind on that you scrutinise that with the care that those facts, in fact, obviously merit. Thank you very much.
the Chamber rules as follows. The Chamber was seized of the prosecution application for grant of protective measures in the courtroom for witness 487 in the manner of voice distortion, facial pixelation or distortion, use of pseudonym, and limited use of private sessions to discuss sensitive information that may reveal the identity of the witness or those of family. The Chamber has since received the recommendation of the VWU in which the unit indicates that they have spoken with the witness and assessed the witness, and the witness has indeed expressed fear for his security and psychological well-being. In the circumstances, the Victims and Witnesses Unit recommends the measures indicated, which is voice distortion, facial distortion or pixelation, use of pseudonym, and limited use of private sessions. Of course, we heard Mr. Hooper's brief but pointed observation that the Chamber must assess what the Victims and Witnesses Unit recommends, and that is a correct observation. Nevertheless, the Chamber also notes that the Victims and Witnesses Units have a measure of expert that is peculiar to their work, and some deference, Korean deference, as we say, Korean deference will need to be accorded to the recommendation. Accordingly, the Chamber grants the measures requested by the prosecution. That is the ruling. It is now 17 minutes to 1. I think we should begin the testimony of the witness, notwithstanding that we will have to put the witness, release the witness for break in 17 minutes.
Your Honors, I think some progress can be made in that time.
So let us then bring down the clients and bring the witness into the courtroom.